Good morning. I'm Bonnie Gardner, co-chair of the Public Affairs Forum of the First Unitarian Universalist Church of Austin. Welcome. Our forums occur most Sundays at noon, and they're free and open to the public. We encourage you to attend. You can find out more about our public affairs forums by going to our church website at www.austinuu.org. I'm very happy and honored to introduce today our speaker, Clyde Farrell. He's going to be speaking on legal and financial planning for later life, often missed opportunities. Let me tell you a little bit about Clyde. He graduated from UT as an undergraduate in political science, and then he went on to the University of Texas School of Law in 1975. He is a former chief of the Texas Attorney General's Consumer Protection Division, and he was also chief of the Elder Law section. He's a certified elder law attorney, a certified financial planner, and a founder and past president of the Texas chapter of the National Academy of Elder Law Attorneys. I think he was also on the board of the National Academy of Elder Law Attorneys. And he served also as a volunteer and attorney consultant with Family Elder Care in Austin. He's past president of Family Elder Care. He is a partner in his firm of Farrell and PAF. And this is consistently selected as one of the best law firms in Texas in elder law almost every year, and Clyde is cited as one of the best attorneys in Texas. He has incomparable expertise in the field of elder law, and basically he wrote the book on elder law, I think, in Texas and maybe even nationally. He's trained many other elder law attorneys in the state and across the nation, and he's been very generous in donating his time to conferences, teaching, various charitable organizations. When Clyde talks, you can count on what he says to be right. So let me welcome my good friend of many years, Clyde Farrell. Thank you.
Thank you, Bonnie, for that kind introduction. If you're like me, you're bombarded with information every day. There's just too much of it. So, for example, now you can Google the question, why do I need a will? And get some pretty good answers. So that's not what I'm going to talk to you about today. I decided in my speaking I need to talk about things that you can't look up on the Internet, things that are pretty much restricted to information that's pretty much restricted to people who've had the experience that I've had. And so that's how I came up with the topic of missed opportunities, often missed opportunities, and underutilized strategies for planning for later life, legal and financial planning. So that's what we'll be talking about today. The slides will kind of give us an outline. The missed opportunities I'll mostly be talking about orally, so it'll be some of both. The folks who come into our office are often the adult children who are planning for their parents. And we ask their goals. There are many goals that may be involved, but quite often what we hear is, we're here to protect our parents' assets by getting them the cheapest care that we can. Thank you for laughing. We try to gently redirect the attention to a goal of something more like plan for the best quality of life for your parents, the best quality of life they can afford. And in most cases, people come along with that. We don't often have trouble with moving it in that direction. I'm happy to report. But I'm suggesting to you, this is one reason, don't leave the planning to your children. They have a conflict of interest. There's an inheritance in there. And even though it may be something that no one ever talks about in the family, it does influence all of us. To be honest, all of us, when we think about an inheritance, it may influence how we do these things. And Also, I want you to know that the marketplace does have a lot of expensive plans and products that are really not good ideas. I'll give you one just because I feel so strongly about this, and that is the idea that you can transfer everything you have to an irrevocable trust for someone else, for your children, and therefore get eligible for VA pension benefits immediately and Medicaid benefits maybe in 5 years. I think that is a terrible idea. I will tell you frankly, even though people are selling that as we speak today. When you do that, you're putting what you own or whatever you put into the trust is in the irrevocable ownership of somebody else. You are not the beneficiary of the trust. Maybe you reserve an income interest, but if you do that, then it won't work for VA benefits. But the trustee cannot legally help you at all. But what they will tell you, people who sell this device, will tell you, well, this is for your children's benefit, but wink, wink, nod, nod, the trustee can distribute anything to them, and then they can help you. And it comes kind of around. But what they don't tell you is, if you were to disclose that to the VA or to the Medicaid program, both of those agencies would immediately say, oh, well, if that's what you're doing, then you're really a beneficiary of this trust, and therefore our benefits are not available to you. This is if you own this and it was in your bank account. If you fail to tell them that, you have failed to disclose a material fact, which is called fraud in my world. And I think it is just unconscionable that this sort of thing is going on. The VA is onto it. They're changing their rules around as we speak, and we expect the new rules to come out any day to help discourage this sort of thing. They're going to implement a 3-year transfer penalty, much like the Medicaid transfer penalty, which is a 5-year look back, and in some ways tighten this up, but there's still the possibility of abuse. So this is an opportunity I suggest that you not accept. The next slide shows several resources that we often see underutilized. I'll just mention the first 3 there now, and we'll talk about the last 2 later because they're so important. Reverse mortgages, they're oversold sometimes, yes. The interest rate can be high, yes, particularly if you only use them for a short time. But I have seen wonders done with reverse mortgages. Life insurance. Every once in a while we see someone who's life insurance poor, who has several $100,000 in life insurance coverage that they could either borrow on or sell or cash in, or they could sell the policy. And that could move you from being poor to being relatively well off. We see every day what I call underutilized assets, people who own a home or even sometimes several houses that are vacant or they're being rented for below market rent. That can make the difference in being relatively impoverished or relatively well off. And we'll be talking later on about the tax deduction for medical expenses and VA pension benefits. The effects of taking all of these resources into consideration can be dramatic. The best way to do this professionally is with cash flow illustrations. You can tell how much difference it would make over time. When I first became a financial planner back in 1987, my first financial plan was for my parents. I ran their income and expenses and what they expected. They at that time had already retired. And after I'd done all the number crunching, I was able to tell them, well, Mother and Dad, you're doing quite well. As your financial planner, I advise you to travel, do what you want to do. I knew they wanted to travel. And they did. Because they could see in 3 colors that they were doing fine, that they didn't have to keep saving as they had for decades. As my brother and I were growing up and as school teachers, they were struggling. They could now relax and do what they'd always wanted to do, and they did. They literally went around the world. And I've seen this with my clients. It's not an unusual situation. So this is a word of a bright word to leave you with, that sometimes planning can lead to a much better life. And cash flows can also help you answer the questions like, do I need long-term care insurance? If I do, how much do I need? Do I need to rely on Medicaid, or is there a better alternative for me? And another benefit of planning is that it requires you to look at potential expenses you might otherwise neglect, such as the expense of long-term care. My wife Kathy and I had breakfast this morning, as we usually do, and Kathy, we were talking about my talking today. Kathy asked, well, what is the most important thing for someone to know in planning for later life? It didn't take me long to come up with the answer. The most important thing to know is that you need to think about planning for long-term care. That is the thing the biggest mistake. That's how she asked it. What is the biggest mistake people make? And the biggest mistake is not thinking about long-term care. And that's understandable. Several years ago, my dad was the president of the Bell County Retired Teachers Association. He called me and said, Clyde, we'd like for you to come and speak to us. What do you want to speak on? I said, well, Dad, I do a lot of planning for long-term care. I could talk about that, planning for nursing home care, whatever someone needs in later life. There was silence at the other end. Silence. And after a while, my dad said, well, Clyde, can't you talk about something less gruesome? So I admire your courage coming to hear me talk about these gruesome things today. And I must share with you that is the biggest mistake that I see, to not think about that. But if you do the planning, then you're more likely to utilize these resources that we're talking about, the overutilized resources and the underutilized resources as well. Now, the next slide lists types of long-term care. This is just to kind of get us thinking about what we're talking about here. Generally, the higher you are on this list, the higher your quality of life. We start with home health care. I'm proud to say that we kept my dad at home for 4 years at a time when he could have he could have used nursing home care, but he had one person with him all the time who had nothing to do but attend to his every want and need. That is such a different life than being in a nursing home where you have maybe 4 or 5 or more people to one attendant and all the other differences. An assisted living facility compared to a nursing home generally allows you to have more alert people around, much higher quality of social life, and on and on. It's really important what kind of care setting you're in, and that's why we try to steer people, if we possibly can, we try to steer them away from Medicaid nursing home care. That's kind of the default in our minds because many people need that, but we try to find those opportunities for better quality of life. An underutilized resource in this area is care managers. When we decided whether my mother could stay at home as my dad did or not, we brought in a care manager, a nurse, who is very good at these sorts of things. She had already assessed a couple of aunts of mine, and I had the feeling that she was going to really give us the confidence that we had done what we should. Unfortunately, what she told us is, now your mom's going to have to be in a nursing home because she has a condition in which she may aspirate food. There's a likelihood of that, and you've got to have nurses around, or it could be life-threatening, and that's not what we want. So the bottom line there is to be really confident that you have the highest quality of life, you need expert advice. And what looks like free advice from someone who's selling home care or selling nursing home care may be very expensive in the long run in terms of your goal of getting the best quality of care. Now, the next slide I'm going to skip over quickly because this is just a listing of ways of paying for long-term care, and we're going to talk about all of these, starting with long-term care insurance. Now, this is an example of a resource that will not be available, 100% guaranteed will not be available if you don't think about it now, if you don't plan in advance. You cannot insure your house when it's burning down. All right? And the same principle applies here. They will not insure your long-term care, even if you even are talking to them on the phone and you forget something. My wife had that experience. I'll use Kathy as an example again. When we applied for long-term care insurance many years ago, Kathy was talking to the person who was doing a phone interview, and she forgot some little trivial something, and we almost didn't get the coverage because they thought that Kathy, who's one of the smartest people I've ever known and still one of the most alert, but was on the verge of dementia. So this is, I don't want to scare you, but I do want to motivate you. If you're thinking about doing this, to do it now. Don't put it off. It won't get any easier. That was a pretty tough test we were going through. They have different standards. We got a pretty cheap policy because we met high standards. But that doesn't mean everyone should have long-term care insurance. Some people have enough assets and income that, based on their goals, they don't really need long-term care insurance. And this slide gives you a summary of how I generally look at the goals. Is your goal to avoid impoverishment? That is, to avoid using up all your assets. If that's all your goal, then you may not need so much long-term care insurance if you're willing to use some of your assets for that purpose. Or is your goal to avoid spending any assets? Is your goal to avoid spending any of your income? Or do you want to insure for the entire cost of long-term care, even though you have income coming in that could offset that? But it's very important to not just look at what the salesperson talks about in terms of what care costs, but also look at what other resources available you have that you may well want to self-insure with. There's a lot more to it. Now, another way of paying for long-term care is Medicare. The slide gives you some basic information on that. I'll just talk about the missed opportunities. People are often told when they're in a nursing home and the 100-day maximum for Medicare coverage, they're saying, no, you don't get the full 100 days because you're not improving. That's an old standard. The improvement standard has been abrogated legally, and now the standard is you get the Medicare coverage, Medicare care, if it would at least keep you stable, at least if you need it for the purpose of keeping stable, and you don't necessarily have to be improving. And the same is true of home care. So a lot of people are misled on that. Now, one of my favorite ways of paying for long-term care is tax savings. I've seen a number of cases in which people could save more with tax savings, given their incomes and their situation, than they could have saved with Medicaid, because they're able to use retirement accounts on a tax-free basis to pay for long-term care. Here's how that works. If you qualify, even room and board at nursing homes and assisted living facilities is deductible as a medical expense. So if you're paying $50,000, even $100,000 a year in nursing home or assisted living facility costs or home care costs, you're probably going to be able to deduct that, and you won't pay any income tax. You may even be able to use retirement accounts to make those payments and turn accounts that otherwise would have been taxed, either to you or to your children, into tax-free accounts because all of the tax is offset by the income, by the medical deduction. Now, unfortunately, what I've been talking about is a minority of Texans who are able to pay with retirement accounts, use the tax shelter. For most Texans, Medicaid pays most of the cost of long-term care, and it can't be avoided. Over 70% of Texas nursing homes residents their care is being paid by Medicaid. Let's see a little more on the next slide about the Medicaid specifics. I'm not giving you all the Medicaid rules here. I'm just hitting the high points so you are oriented to it. There's supposedly an income cap of $2,199 a month on Medicaid benefits. One thing to go away from here today with is that income cap can always be avoided simply by running the income through a trust called a qualified income trust or Miller Trust. So don't be misled about that. We occasionally find someone who's been in a nursing home for years and someone in the family has been paying for part of their care to supplement their income, and that really wasn't necessary. And there certainly are strings attached to Medicaid. There's the estate recovery program. Medicaid may turn out to be just a loan program if you have property that you don't protect from the Medicaid estate recovery program after your lifetime. And there's a 5-year look back for transfers. Whenever you apply for Medicaid, they ask, have you given anything away? And if you have, then you may be ineligible, depending on whether an exception applies to that. However, the next slide talks about why avoid Medicaid if you can. Over 90% of Texas nursing homes are Medicaid certified, but the private pay facilities tend to have better care. I spent 10 years with the Texas Attorney General's office suing nursing homes. That was a big part of what we did with the elder law section. And we probably sued 120, 130 nursing homes in that time. None of those were private pay nursing homes. They were all Medicaid nursing homes. Here's why. Here's why in my view, better care is available in those private pay homes. Generally, it's because the Medicaid rate is being subsidized by private pay residents. Medicaid pays approximately 80% of the real cost of long-term care. Guess who gets to pay the rest? The private pay residents who go to the nursing home. If it's a Medicaid certified nursing home, I think of that as a tax on getting old and sick and going to a nursing home. Our legislature, in its wisdom, requires that the Medicaid program be subsidized by that instead of being paid for up front in taxes by us. This is an area in which I would like to pay more taxes because I don't think it's fair for people who have to go to a nursing home to subsidize the Medicaid program. But there is a way to avoid that, and that is to go to one of the private pay homes that don't have to subsidize the Medicaid program. Not only do they have more coming in per person, they don't have to, on private pay basis, but they don't have to use any of that to subsidize the Medicaid program. Now, the next slide is on VA pension. That's an underutilized resource. I complained earlier about how people sometimes transfer assets to an irrevocable trust to get eligible for it, but that doesn't mean that I object to it. In fact, I'm proud to be able to steer veterans in that direction quite often who had no idea that they could use it. Here are some missed opportunities in that area. All medical expenses, including usually the cost of long-term care, can be deducted from income for the purpose of determining whether or not a veteran qualifies for the VA pension benefit. Therefore, a veteran who needs long-term care, a substantial amount of it is probably going to qualify as far as income is concerned. That's usually a no-brainer. Even home care can be deducted as a medical expense in most cases. And another little-known fact is that a married veteran can get the whole VA pension, potentially, depending on their income, even though an unmarried veteran will have their Medicaid benefit reduced to $90 a month. They'll have their VA pension benefit reduced to $90 a month if they qualify for Medicaid. A married veteran can qualify for Medicaid and still get up to the whole VA pension. Little-known fact. Now, the next slide talks about when Medicaid can't be avoided, some often missed opportunities. I've mentioned the income cap. You can always avoid that, so don't be taken in by that. There are some home care programs that don't have a transfer penalty, so you actually can, let's say mom has $30,000 in assets, she can get eligible for home care Medicaid, some home care Medicaid, and some other Medicaid-sponsored benefits by transferring assets to the children. That's a very much an individual decision as to whether that's a good idea or not. If there is a spouse who's not on Medicaid, all the assets can usually be protected in some form. This is another take it away from here today point. That when one spouse is at home, the other's in a nursing home on Medicaid, or if both spouses are in home and just one needs Medicaid benefits for home care, it's usually possible to shelter everything. And sometimes the shelter takes the form of if they have low income, if their incomes are low enough, they can keep a lot of assets. We have occasionally protected as much as $1 million in assets when incomes are low. There's a complicated formula I don't have time to go into, but low income, and they don't even have to be very low if it's a home care program under a new rule that was announced recently. So if there's low income, it may be possible to protect all the assets. You can usually protect half of the assets, and the other half can usually be spent on paying on the mortgage, credit card debt, buying a car that you need anyway, buying an annuity for the spouse at home. That's why I say we can usually protect most of the assets when there's a spouse at home and the other spouse needs Medicaid. So avoiding impoverishment of that spouse at home is a legitimate goal of the Medicaid program, and it's one that should be maximized whenever it's necessary. Now let's move to another general topic, and that is legal and medical decisions. This is where we get into some of the more straightforward planning opportunities that most of us know about. Let me just focus on the most important. There's a story, I think it's apocryphal, but a story that an older man, a 93-year-old man, came into our office one day, and we were talking to him about powers of attorney. He said, "Well, young man, I'm 93 years old. I've never needed a power of attorney. Why would I need one now?" Well, thank you for your laughter. That means you understand that the older we become, the higher the likelihood that we may lose the capacity to make our own decisions during our lifetime. This is not after your lifetime like a will. This is during your lifetime. Who's going to make your decisions about whether you're going to get an operation, medical decisions, or managing your bill paying, or managing your assets in various ways? Who's going to do that? You get to decide with the powers of attorney. And there's some missed opportunities regarding powers of attorney. I mentioned that sometimes it is a good idea to get Medicaid benefits. Sometimes making gifts to family members, transferring assets is a proper way to do it. You can make one spouse eligible. You can keep one spouse eligible only by transferring everything to the other spouse. But what if the spouse who's on Medicaid is on Medicaid because they've lost the capacity to make their own decisions? Then how do you transfer everything over to the other spouse? Well, it gets very difficult unless they have the right power of attorney. If they have a power of attorney that they pulled off the Internet and signed or bought in a store somewhere, it's probably not going to permit the agent to transfer assets to a spouse or to a child with a disability or someone who legitimately you would want to transfer assets to if it would make you eligible for Medicaid. So that is an often missed planning opportunity. And just the fact that mom or dad selects who's going to be the agent can avoid a lot of expense in court if someone would otherwise have to apply for a guardianship. powers of attorney generally avoid the need for a guardianship, and that's one of the main reasons to do them. And finally, a missed opportunity in this area is that there's a statutory form for a directive to physicians that gives you it asks two questions regarding what you want in end-of-life care. One is, what do you want done if you have a terminal condition? The other is, what do you want done if you have a condition like being hooked up on tubes, that sort of thing. There are other forms that have a lot of questions. They may be really good questions. For example, one question is, assume you're unconscious and medical testing indicates the unconsciousness is permanent. If you contract pneumonia or another condition that can be treated with antibiotics, do you want the treatment? It's not real clear from that statutory form what the answer would be, but if you sign a longer form, then you can answer that for yourself. Okay, now we're finally down to the last topic we have, which I'm calling legacy. And here we have a list of end-of-life legal documents. I'm going to skip over this slide just for the sake of time. You have it in your handout. That's just sort of a checklist. And moving on to benefits of a will or living trust. Well, you're probably pretty familiar with that. Either one can determine your property goes to persons you select. You can avoid the need for guardianships for children or other people who need a guardianship by providing for a trust for them, whether you're using a will or a living trust. Probate costs are lower if you have either. Estate tax can be saved. You get to select the executor or guardian. You can waive the expense of a bond. And then benefits of a living trust over a will. Let me just focus on some purposes that I think are not as well known, or that can really make a living trust a much better choice. And that would be, the main one I see is that if you have property that you want administered by a bank or a trust company, they will not act as a power of attorney agent. You have to use a trust. And so if you're, let's say, if you're like me and Kathy and you don't have children, or you don't have children that you feel would be trustworthy for managing your care, your assets, then it may make sense to provide that everything goes into a trust, and maybe the spouse is or maybe you and the spouse are the initial trustees, but you may want to make a good bank or trust company an alternate trustee in case you lose the capacity to make your own decisions. And then another slide, benefits of a will over a living trust. Here I've said this is mandatory. You must use a will if your goal is to protect the surviving spouse, and the surviving spouse is on Medicaid. Because of a quirk in the Medicaid law, there's no good reason for it. It's just a legal quirk. A trust that's established in a living trust that's not established by will not work for Medicaid purposes. Here's what we normally do. One spouse is going on Medicaid. That spouse must transfer at least all the countable assets to the other spouse to keep their Medicaid benefits after the first year. We go one step further and provide in the will of that other spouse who now owns everything. If I die first, everything goes into a trust for my spouse who's on Medicaid. That works very well, but it only works if you have a will. That trust has to be created by will, or the Medicaid program will not stand up and salute it. And all of those assets will be treated as assets of the surviving spouse, who will then have to spend them down in order before they can get back on Medicaid. Another benefit of a will, of course, lower initial costs. And that's because of the third bullet point there. There's no need to transfer existing property to a trust. To establish a trust properly, one of these living trusts, to try to avoid probate, you have to put everything you own into it. You have to essentially do what your executor would have to do after your lifetime. You have to find all the property, put it all in one place, in one trust. You don't have to do that with a will, and that's one of the big advantages. In general, it's less trouble and expense for you if you use a will rather than a living trust. And I'll add there another not too well-known fact, and that is living trusts almost never avoid probate. They're sold by financial planners and sometimes by attorneys as probate avoidance techniques, because in theory they can, and occasionally they do. They almost always don't, because the person who establishes them, whoever's helping, the attorney or whoever's helping with the trust, doesn't put everything into them. I just routinely see these huge notebooks come across my desk with trust instruments. I've seen 200-page trusts that were not funded with anything. And the trust does no good if you don't put something into it. It's like a basket. All it is a basket that someone has paid $2,500 for. If they don't transfer their assets into it, they have to sign deeds and transfer instruments of all kinds, get their bank and their brokerage to have them sign new account agreements, and on and on and on. That's why it's more expensive to establish them, but it usually doesn't get done. But even if it gets done, then the problem that arises is maybe you buy a piece of land or you buy a new home, and you just don't think to put it in the name of the trust. Well, the trust isn't going to avoid probate. You've probably signed a pour-over will that says, after my lifetime, anything I own that's not in the trust goes into the trust through the will. And guess what? Those pour-over wills are almost always probated. I've heard an estate planning and probate attorney more experienced than I am in this area who said he has never seen a pour-over will that wasn't probated in the probate situation. I've seen a couple of them, but it's almost always true that those pour-over wills get probated. And then finally, when is a trust needed for the surviving spouse? I've already told you the situation in which I see it needed the most, and that is when Medicaid benefits are involved. Sometimes when there's estate tax planning issues, I've given you a little summary of situations in which that can be important. Usually not, but occasionally so. And sometimes if the surviving spouse has creditor problems, then it may be a really good idea to provide a trust for them. Or if they're likely to have creditor problems because they can't manage money, then you definitely want to provide for a trust for them. So I guess you can see that this is very much a custom job. There's not a one-size-fits-all answer to this question of when is a trust needed for both spouses or the individual, and when is a trust needed for the surviving spouse. Sometimes it is a critical need that can be done only with a trust. Other times, the trust would be superfluous and only creating problems, and knowing which of those categories your situation falls into requires a lot of careful searching. I think we're all ready to go on to questions now.
Well, let's give Clyde a big hand so far. Thank you.
Somewhat of a unique problem that I think may be resolved. Up until the last 2 or 3 years, Michael and I, who've been together for 36 years, were legal strangers. We're legally married now, and I believe Texas even thinks we're humans. But my question is, are there quirks that you're aware of that make us still unprotected? We do each have our own living trusts.
Thank you. That is such a good question. And congratulations on the answer to the question. The answer to that is no. I have not seen quirks come up in my practice that made, now that we have the latest Supreme Court decision, I have not seen anything indicating that same-sex marriage partners would be treated any differently than opposite-sex marriage partners. It has just been a non-problem since that decision.
Edwards. Are there any problems I should be aware of about using payment on death or transfer on death forms from banks and places like Vanguard or Fidelity?
Okay, yes. The biggest problem with using a payable on death form or transfer on death form is it may cut out some people that you otherwise would want to receive assets from that account. Here's one problem. Let's say you have 3 children, and one of them is joint with you on an account, and that has a right of survivorship or a payable, or you make one payable on death beneficiary but not the other. Your will probably says to my children equally, then that one that you've given the payable on death right to gets that money first, and then your will only divides the rest of the money. Most of us aren't aware of that, and so you may be unwittingly favoring one child. Another problem is cutting out grandchildren. What if you have one child and there's a payable on death provision? The children of that child are not going to get anything under the payable on death provision, but they do under your will probably. So there's another situation where you have to look at everything involved. And the general rule, I have to tell you, is if you want a one-size-fits-all rule, it's don't use payable on death or survivorship provisions because it's so common to have these unexpected results happening. But the best advice is to work with your attorney, estate planner, to come up with the best ways of transferring the assets so that they will accomplish your goals and in the least costly way possible.
And I have a question about your statement about paying for the cost of long-term care with tax savings and about the assisted living payments that you make monthly. So is the whole monthly payment that's like for room and board and an aid assistant, all of that is a medical deduction?
All of that can be a medical deduction and usually is. You need to have a form filled out to assure that. It's called a safe harbor form. Okay. I believe one of the slides gives you a URL to our website where you can get that form. It's certification of chronically ill individual, and in that a doctor, an RN, or a licensed social worker certifies that the person involved either needs help with at least 2 of the 6 activities of daily living or has severe cognitive impairment. Either of those situations will qualify the person to deduct all of the cost of the assisted living facility or nursing home. So I recommend looking at that closely. It can really make a huge difference.
Thank you, Bonnie. Thank you for your time and your expertise sharing them with us today. Tell us about the kind of work you do. If people need this kind of advice, obviously you just touched on part of it here. What does it cost? What does it cost people to get this kind of counseling? And give us some benchmarks for that, would you?
Okay.
Thank you.
I think the best attorneys who work in this area are real flexible on what they charge for these things. I have had people who've come in and they just had a focused question about Medicaid benefits, and that's what we start with. We start with an initial conference fee, and significant number of times we're able to do everything the person needs. If what the person needs is comprehensive planning for determining, do I need Medicaid benefits? If so, what are the strategies for planning for them? That's likely to cost just the planning part. Let's say if you were not going to need, you don't have an immediate need that doesn't involve any Medicaid application or anything like that, that's likely to cost in this area between $2,500 and $5,000, the planning process. And that would include wills, powers of attorney, the documents that you need for the process. If a Medicaid application is needed, that generally runs about the same range, or more often toward the lower end of that range, if you do need to apply for Medicaid.
Mr. Farrell, thank you for your presentation today. I'm curious as to alternatives for purchasing a long-term care policy from an insurance company. Do you have any suggestions and strategies for that?
I think the main thing there is one thing is if you're a member of a group that offers that kind of coverage, then by all means look at the group coverage and compare it to the coverage you can get in an individual policy. In any case, you should look at individual policies, whether you're a member of a group or not. And there, the best advice I can give you is talk with an insurance agent that you trust, someone you're referred to as an agent that you can trust to do right by you. And in general, my suggestion there is ask the agent to take into account your income and your assets that you're willing to apply to your long-term care. The agent, as I mentioned earlier, will start with, well, it usually costs in this area for nursing home care upwards of $6,000 a month, maybe $6,000, $7,000, $8,000 a month that they're likely to use for an illustration. And they may just offer you that coverage. But if you have $4,000 a month steady income with an inflation increase, and let's say you're unmarried, there's no one else depending on you, why would you want to pay the premiums for a $7,000 policy when you really only need $3,000 of coverage? The agent probably won't take you down that road, but if it's a good agent, they'll go down the road with you, and I'm suggesting that you start that.
Would you please explain a living trust again? I know you went over it, but I didn't quite understand it.
Yes, I think the basket metaphor is a good one. With a living trust, you sign a trust instrument that says, I'm going to administer everything I own as trustee. And if I become unable to do that, or at my death, somebody else, maybe a bank or trust company, maybe a child or a spouse, will become trustee. If you put everything in that basket, then at your death, it just stays in the basket. If the provision is that at your death it continues for a spouse, or more commonly, it gets taken out of the basket by your children. The trustee takes what you own, gives it to your children the way you said in the trust instrument. And that process of taking what you own out of the basket by the trustee is what avoids probate, if it works.
But I thought you said a friend of mine has a trust, and I think she said she avoided probate. You said different.
He said that she said a friend of mine. What was it? She has a living trust and says it avoids probate.
Oh, sure. I've seen that happen. Congratulations. That's an unusual case. I'm glad to hear that happen. And I'm not saying it can't. I'm just saying it usually doesn't.
I'm Elaine Goodson. My question is, other than family elder care, for people who needed financial help, is there another group in town that can provide that kind of financial services to somebody with dementia?
You're asking, is there another group other than family elder care, that can provide financial services to someone?
Paying bills and that kind of thing.
Oh, bill paying.
Yes.
Mm-hmm.
Oh, okay. I don't know of another group a nonprofit group that does bill paying. There certainly are individual bookkeepers who will do it for a fee. I think that's the extent of my knowledge on that.
We have a question from John Franks.
Yeah, some people now are suggesting that you add a dementia provision to your advanced care directive. Can you speak to that at all?
I'm sorry, I didn't understand.
A dementia provision that if you are certified as being demented and can't make any decisions for yourself, then life support, feeding basically, feeding and watering then will be withheld.
Bonnie, can you help me? My ears are not picking it up.
He's asking, can you put a dementia provision in your advanced care directive such that if you have diagnosed dementia, you support systems, feeding and providing fluids is withdrawn. Is that the correct question?
Okay. Oh, that's a tough one.
It is.
Oh, yes. Yeah, as I mentioned, the statutory form only addresses a terminal condition or an irreversible condition. It doesn't give you the option of saying, if I have irreversible dementia, don't feed me, don't give me water.
I may add something to this since I have some expertise in the area of dementia. It's important to realize that there is very severe dementia, but then there can be very, very mild dementia, and where you may have it diagnosed, but you could still perform some activities of daily living, respond to loved ones, and engage in some kinds of self-care. So to me, the term dementia in and of itself, the diagnosis would be overly broad. You would want to be very specific about functional capabilities.
I agree with that. Legally, a diagnosis of dementia does not in itself prevent someone from signing a valid will. Wills have certainly been upheld by people who had a dementia diagnosis. But to be fair to the questioner, I think what we're really asking here is, under any circumstances that are well set out of dementia diagnosis, I think the way I would frame it is, would someone who's acting under such a directive by withholding food or water have a legal defense to prosecution for assisted suicide or murder? And I think the answer to that is we're not sure. I had someone ask me that not too long ago, and that was the conclusion I came up with, that there is not a clear answer to that anyone who acted on that basis would be taking a significant risk.
We have just about 4.5 minutes left. We have a question from Margaret Borden.
Thank you. There are many people these days that, as they get older, and especially if they don't have a surviving spouse who is capable, need someone to manage their finances. You mentioned the 93-year-old man who didn't know why he needed a power of attorney. Need someone to manage both their medical and their financial matters. So how does one go about finding those? Are there professional organizations? Are there, I would think dealing in this area you might know what people find, but perhaps not.
Okay. Yeah, what I see done most often when someone doesn't have a family member, of course usually it's done by family members, but let's say you're in the position of many people who do not have a child or other family member that can be relied upon to take care of these things. Sometimes there's the option of a bank or a trust company as trustee. I mentioned that. And paired with a care manager as medical power of attorney agent. Some care managers will serve as medical power of attorney agent, and that would be ideal if you don't have a family member who can do that because of their medical expertise. So that's sort of the A list. That's the best way of doing it if you have enough for a bank or a trust company to manage. Otherwise, I don't have a good answer to that, unfortunately, and you're really there are people who do management. Very few people do, and the reason is that it is so common for individuals who undertake to manage other people's finances to get attacked by family members of the person, or the heirs who think they've been robbed by the person spending too much on the person, or sometimes they really do step over the line, sometimes not intentionally, but they are at risk. So I think it's a big problem. Family elder care will act as a guardian, and other nonprofits will act as a guardian, but they won't act as a power of attorney agent. So getting a financial power of attorney agent who's responsible and willing to do it is a tough problem.
Well, we're down to our last 2 minutes. Do you have a very quick question? Okay, Linda.
Suppose one needs to go to a Medicaid nursing home. How would one choose the best one?
The best answer to that is work with a care manager, a geriatric care manager. They know first of all, they can pair your needs with what the facilities will provide. They can save you a lot of time looking around to do that. And if they're experienced, they've been in those places, they know how they treat their other clients, and they can give you the benefit of that expertise. In my office, we don't give that kind of advice, what nursing home should we go to. We send people to a care manager. We don't want the responsibility, frankly, and we think the care managers can provide that better. I tell people, I don't want to practice nursing without a license. I'm going to send you to a care manager who's a nurse or a social worker who can help you better than I can.
Well, would you take just 1 minute and give us a closing statement, please, Clyde?
Well, I can tell from the questions that you all are really thinking about this. You're beyond where my dad was when he objected to talking about these gruesome things. And so I would encourage your continuing to do that. You're on the right path, and I would encourage you to look at the bright side. Look at the possibility of a better life in retirement or in later life, whether you're retired or not. I'm in later life. I'm not retired. I'm having fun, and a lot of us are. Read Jane Fonda's book.
Well, we want to thank you so much. This is invaluable information. It's so helpful. Let's give Clyde Farrell a big hand. Thank you.